sometimes clients will be shocked when they see the number. They're expecting to get, $15,000, $20,000, $40,000 back, however much they've actually put out thus far, or whatever number they see there on their purchase agreement as the price of the vehicle. And when they see what they're actually getting in the check that they're going to be handed on the day of the surrender, they're not so happy and they're shocked at what that number is reflecting.
Welcome back to Lemon Law Unpeeled, the Lemon Law podcast. I'm Emma.
And I'm Courtney.
And I'm Steven.
And today we're going to talk about lemon law outcomes, repurchases, replacements, cash settlements, how the process works, and what to expect once your lemon law claim is resolved. So there's 3 potential outcomes when you have a lemon law claim that you can expect. You can either get the repurchase of your vehicle, the replacement, or a cash settlement. Repurchase and replacements can be pretty similar, but Courtney, I'll let you kick it off just talking about what does a repurchase mean when a client is awarded that or that's the offer that they receive from the manufacturer.
Yeah, so the repurchase is really the home run. That's really the best thing that we can strive for. It means it's basically undoing the deal of you purchasing this vehicle. So you're going to get back your down payment and all monthly payments that you have made up until that date. They're going to take the vehicle back from you and they're going to pay off your loan. So I always equate it to returning a shirt to a clothing store. And then you are free to go ahead and get whatever other vehicle you want. A lot of times clients will ask, well, do I have to get the same brand? Do I have to stay with the same manufacturer? Is the money going to come back to me as a credit? And the answer is no, absolutely not. It's going to be a check that you will either be handed the date that you surrender your vehicle, or some manufacturers mail it out to us the date that you surrender your vehicle. So you'll have it within a week or so. And it's just a check made out to you, and you can then take it and go wherever you want to go and get whatever you want to get. So it's really the best thing that we can hope for.
Each lemon law with a repurchase, though, it comes with some deductions. So it's not a perfect one-to-one. Steven, I'll let you talk about what the most common deductions are that we see when it comes to repurchases, and some of which it's not necessarily a deduction, right? Some it's just you don't get it back from the manufacturer, but you can get it back from another party. I'll let you kind of discuss, the usage, extended warranties, taxes, that sort of thing, and how it works for our repurchase as well.
Absolutely. So every state has their own formula to calculate a repurchase. And depending on which state you have, there are some things that are deducted right off the bat, and there's some that are actually given back to you. For example, extended warranties can either be deducted based on your state or reimbursed to you. For example, in Georgia, the manufacturer is required to reimburse the full price of the extended warranties, whereas in some other states, that is not always the case. Another common thing that is deducted are rebates. These are not cash that you paid. These are incentives that are given to you by the dealership. So it's not actually a cash amount that you will get back, but that is deducted because that was an incentive you received at the time you purchased or leased your vehicle. Negative equity is another thing that needs to be noted. Sometimes you roll over a loan from a previous car when you trade it in and get the new vehicle that you have that's now a lemon or has breach of warranty issues. The negative equity does not go away. So if there is money owed from that previous vehicle or loan, that is owed. So that will be deducted as well. The fourth thing that is deducted for a repurchase is the mileage usage fee. Every state has their own way of calculating how much can be deducted based on the mileage of your vehicle at the time of the repurchase. So don't be shocked when you see a mileage usage deduction fee, because that is going to be applied to your vehicle.
Yeah, a lot of clients kind of get upset over the usage fee. Obviously, it depends on how much it is, right? Like PA's is pretty small. It's 10 cents per mile up to when the problem started. New York's is any miles over 12,000. Everybody's a little different. The toughest mileage deductions are in states like New Jersey, where you multiply the amount of miles you put onto the vehicle up to when the problem started by the purchase price, and then it's divided by 100,000. So the higher purchase price you have, the higher your mileage deduction is, which doesn't really make much sense to me. PA's 10 cents per mile up to when the problem started, to me, is much more clear and much more even across the board. But unfortunately, it's just part of the lemon law, and there's no really getting around it. A lot of clients ask, oh, is this number negotiable? Or why should I have to take a mileage deduction when it's not my fault that the vehicle failed? But unfortunately, it's just in the law and there's no exceptions to it. It's something that you just have to do. And another good point that you made is negative equity. Negative equity can really throw off numbers when we're dealing with these repurchase calculations. Courtney, I'll have you talk about how negative equity and extended warranties, when they're both deducted, how sometimes that can really negatively affect the consumer. The money does come back, not for the negative equity, right? But for extended warranties or taxes. But when you have all of those deducted, or even 2 out of the 3 deducted, it can really throw your calculations upside down.
Yeah, sometimes clients will be shocked when they see the number. They're expecting to get, $15,000, $20,000, $40,000 back, however much they've actually put out thus far, or whatever number they see there on their purchase agreement as the price of the vehicle. And when they see what they're actually getting in the check that they're going to be handed on the day of the surrender, they're not so happy and they're shocked at what that number is reflecting. And it's a couple of things, Emma, that you touched on. One is negative equity. So in other words, if you had $10,000 left on a loan of a vehicle that you traded in and you are now rolling that into this new vehicle, well, that's going to get deducted, right? They're not going to pay off your former vehicle when they're in essence paying off this vehicle. That former vehicle has nothing to do with it. So negative equity would get deducted. Any extended service contracts or extended warranties you paid for on the date that you purchased your vehicle are going to be deducted, though those, unlike the negative equity, will come back to you. It will just be a separate check because the manufacturer doesn't have the money for those things. Those things didn't go to the manufacturer. They're generally were backed by the dealership or by an outside warranty company. So all you have to do is you talk to the dealership, you tell them the vehicle's being bought back under the Lemon Law, and you ask for those extended service contracts, extended warranties to be prorated and refunded, and they will be, and the dealership will give you a check for that. The third thing that might be deducted in some states, not in all states, is the sales tax. So in some states, you're going to get the sales tax back when you get that repurchase check. Other states, such as New York, you do not get the sales tax. The sales tax is deducted. However, you do still end up getting it back. Again, it's just going to come back to you separately. There's a very simple form that we have that we'll fill out for you and just ask you to sign and mail in, and then your sales tax will come back to you from the state. So other than negative equity, the other expenses that you might see deducted, such as extended warranties and sales tax, are going to still come back to you, but it's going to come back separately.
Yeah, you're absolutely right. And it does mess things up sometimes, right? So let's say you purchase this vehicle and you haven't paid enough down to wipe out that negative equity. Because as I describe it to our consumers, the manufacturer is only responsible for the purchase price of your current vehicle. They're not responsible for any money from your prior vehicle. So some clients actually have to come to a surrender cash in hand to actually facilitate the repurchase and make sure that it goes through because they haven't put enough money into the current vehicle to get to a positive level. Instead, they're still underwater, and so they have to owe money to get out of it. And those are really tough conversations to have with clients because nobody wants to see that, right? It's not my fault that this car failed. Why do I have to pay for it? But unfortunately, it's sort of the nature of the beast and is something that's unavoidable with the exception of sometimes maybe we can switch to the alternative of a replacement. Now, a replacement is a collateral swap. And Stephen, I'll let you talk about how that might be a better option for the client in the event that they are underwater and what a replacement means.
Sure. So a replacement is where you are switching the vehicle for a vehicle of the same value or greater value. Now, with that being said, if you get a vehicle of greater value being swapped, that doesn't mean you get all the free benefits of a better car. You have to pay that difference. And normally your financial lender or dealership will want you to bring that difference check in hand to pay off the difference between the higher level vehicle and what you're trading in. Now, a collateral swap means that they are changing the VIN on the title or the loan documents. However, not every financial institute is okay with a collateral swap. So it's always important if you're considering trying to get a replacement to check with your financial lender to see, are they even willing to let you do a collateral swap? That's not always the case. Sometimes they will say, no, we're not willing to do that. However, a replacement will get you a new vehicle. It will get you out of your old vehicle. And then you still have the financial responsibility of the negative equity that you would have as if you still had your old vehicle. But you don't have to come up with the cash right there to pay off the whole amount owed. You still have your normal payments. You still get to drive the vehicle, and it's as if nothing happened with your old vehicle. So with a replacement, this is a great option if available for a consumer who has a great amount of debt or they can't be stranded without a vehicle. Sometimes people rely on their cars for daily usage, and the fact of having your car repurchased means it'll take you a while to find a new car sometimes. You're not always certain. So with a replacement, that car will be available once the settlement is agreed and once that is coordinated.
You're absolutely right. You brought up two really good points. The first one being that when you do a repurchase versus a replacement, right, the timing's not always perfect. Clients have to surrender their vehicle and then they get their check. You don't get the check before surrender, even if the check gets handed directly to you at the time of surrender or it gets sent to your law offices. The timing can be a little off. And a lot of clients get stuck in a situation where they're like, I can't be without a car. Sometimes they can find a dealership that will take a small deposit and they'll hold on to the vehicle for them until the surrender happens. I've had it before too, where I've written letters for clients to their lender informing them that this vehicle will be repurchased and paid off by the manufacturer to allow them to enter into a second loan while this one is still pending. So there are ways that you can try to work with that, but you're right, the timing can be tough and the timeline's not always perfect. And similarly with replacements, like you said, the bank has to agree to do it, the manufacturer has to agree to do it, and the dealer has to agree to do it too, right? And a lot of dealerships these days, I would say out of all three options, replacements are the lowest on the line. The main being that a lot of these dealerships, especially during COVID, sold all their cars. And because the limited supply for the high demand, they sold them for anywhere from $5,000 to $10,000 above MSRP. And those prices have not really gone down. So if we do a replacement, the manufacturer's just going to give MSRP to the dealership. So the dealership's going to lose out on that additional $5,000 to $10,000. And they're independent contractors. So they're just telling manufacturers, no, we're not going to do it. And they're allowed to. So unfortunately, that's what can make replacements really hard, even though the upside to them, like you said, is there's no mileage deduction, your negative equity all just stays bundled in the loan, and your monthly payments stay the same. So it can be really difficult when you're considering which one to take, a repurchase or a replacement, but a lot of times it's simply determined by availability and whether it's even a possibility to enforce, which a lot of clients are like, oh, we'll just go to court. I'll just tell the judge that this is what I want. But the judge can't enforce something that's not enforceable, right? If it just can't happen, it can't happen. And then we're back to a repurchase. But there is a third alternative. Courtney, I'll let you talk about the third possibility that we have, which is called a cash and keep settlement, and under what scenarios that may be more beneficial for our clients instead of the repurchase or the replacement.
Yeah, so the cash and keep is probably the most prevalent outcome of a lemon law or breach of warranty case. First of all, it's a little bit easier to achieve. To get a repurchase or a replacement, the vehicle has to be meeting the state's lemon law, which is a much higher threshold than just meeting the federal breach of warranty statute. So with a cash and keep, what'll happen is you'll get back a percentage of the purchase price, usually 5, 10, 15, sometimes even upwards of 20% of the purchase price of a vehicle, or in the case of a lease, the lease price of the vehicle, and you'll keep the vehicle. Now, a lot of times people think, well, do I have to keep it in perpetuity? Like I can never get rid of it? No, absolutely not. You can sell or trade out of it whenever you wish once the claim is resolved. But it just means that the manufacturer is not going to be taking the vehicle back from you as part of the legal claim. Instead, you're just going to get cash. And similar to the cash that you're getting from a repurchase, there's no strings attached. It's not a dealer credit or a manufacturer credit. You can take that money and do whatever you wish. Sometimes people will hang on to the vehicle. Sometimes people will hang on to the vehicle. The dealer will eventually be able to fix whatever problem they're having. So they're left with a fixed vehicle and they just pocket the money. Other times people will take the money and perhaps even purchase an extended warranty so that they know that they're always going to be covered into the future if the issue is not resolved or crops up again. Other times people will take the money and put it toward trading out of the vehicle, put it toward the down payment of a new vehicle, help offset any losses that they might have otherwise experienced. But the bottom line is it's your money to do with as you wish.
The cash and keep settlement does require the signing of a release, though. It's not a perfect sort of resolution always to these claims. So I'll let you talk about what are the legal implications of engaging in a cash and keep settlement and what does it mean for the future rights of the vehicle owner?
Absolutely. So with a cash and keep settlement, as Courtney said, you're keeping possession of the vehicle until after the settlement's done, at which point you can sell, trade, or keep the vehicle as you wish. However, within the settlement agreement, you are agreeing not to sue the manufacturer for breach of warranty or lemon law claims regarding to that vehicle. So essentially, I always like to explain this to clients when they're like, why can't I sue them if the issue occurs again in the future? Well, you're agreeing to resolve this right now with the manufacturer, and no manufacturer is going to let you keep suing them for the same issue and keep paying you more and more over time. I like to equate that as double dipping or triple dipping. No one's going to agree to that because there'd be no incentive for the manufacturer to settle. You would be able to sue them constantly over and over again. However, one of the most frequent questions I get is, well, with this settlement, is my warranty voided? Is it done? Is it gone? Absolutely not. So as long as your vehicle is within the terms of the original warranty period, the manufacturer is required to comply with the terms of the warranty and work on your vehicle should issues arise in the future after the settlement. That does not mean the warranty goes away, does not mean you're left stranded without any options as long as the warranties are still there. And then finally, we'll also see in the settlement agreement, finally, another right that is preserved for you is personal injury or product liability claims in the future that arise after the settlement. Not things that occurred before, but issues that arise in the future should they happen. So these are the areas that you need to be aware of when you're considering a cash and keep resolution.
Yeah, I always explain to clients, let's say, hopefully this never happens, but let's say you get into an accident or you're injured because of some sort of defect in the vehicle. This does not extinguish your rights to bring a claim for that. But you're right in that it is a one and done type thing, right? Once it's settled, you can't open it back up. If the issue comes back or you have a new issue arise, you can't go back for more money. There are a few exceptions to that, right? There's maybe one or two manufacturers whose release does say that the release is only for prior defects, but those are few and far between. And like I said, it's maybe only one or two of them that actually have it in that release, which generally is only in the release in the pre-litigation phases with them. Obviously, if you go to court, they're going to want a full release where you can't come back. And that's what makes it tricky. I had a phone call with a client yesterday, too, where I have a cash offer on the table. It's a decent offer, and they can settle it with him right now for that cash, or they said we can put it in queue for our repurchase, but it's going to take us longer, and I can't guarantee you that it's going to go through. So he is asking me, what do I do? What do you recommend? Which option do you think I should go with? And as I kind of explained it to him is, usually, the cash settlement is the fastest, and there's no guarantees that you'll get the repurchase. But the money that you're going to accept, you want to make sure that it's enough that if you have to put it aside in the event that you have to trade in the vehicle in the future, is it enough of a nest egg to protect you in the event that that happens? Fortunately, where we were with him is we were pretty close to that number. We were maybe like $2,000 off of where he would be comfortable releasing those rights in exchange for the money. But it's always a case-by-case basis when you're determining, which option you want to take. Courtney, I'll let you talk about too. It also comes down to whether you're going to qualify in the end, right? Yes, if you have a problem in PA within your first year, 12,000 miles, technically you qualify for lemon law. But if we go to court, that doesn't necessarily mean you're going to get the repurchase. And so sometimes taking the cash settlement is the better option because you're just taking too many risks at litigation. Because you're just taking too many risks with litigation.
Yeah, absolutely. I would say it is very far and few between where I would recommend that you pass up a good cash offer to go to court to try for the buyback, because most often we're not going to be able to get it. Number one, you would have to win it at the arbitration phase. A lot of states have arbitration prior to getting to trial. So you'd have to win it there, and then it's going to be appealed. The manufacturer is going to appeal it. I don't think I can think of a single time in 16 years of litigation where I won a buyback at arbitration and the manufacturer didn't just instantly appeal it, which means then we go to trial and you're going to have to win the buyback again at trial. And lemon law, like we've talked about so many times, can be such a high threshold. The vehicle has to be back a certain number of times within a certain amount of mileage, within a certain amount of time. The issue has to be of a certain egregiousness, a certain caliber, a certain severity. It generally has to continue to be ongoing. So say you pass up a really nice cash offer because you think, man, this buyback's a slam dunk, but don't forget it might be months and months before we get to trial. And if the issue becomes fixed during that period of time, we're in all likelihood not going to be looking at a buyback, and you've now turned down that cash offer. Now, can we get a cash offer back later? Yeah, absolutely. But there's no saying that it's going to be as good of an offer, especially if an issue becomes fixed in the interim. And it's a longer period of time that you're now paying on this vehicle that you don't want. Perhaps you're paying out of pocket for loaners or rentals. So it's not generally going to be advisable to turn down a really good cash offer to shoot for that buyback. Though again, there's caveats to everything, and we certainly have seen times where we would advise that.
Right. I had a conversation yesterday, a client in Maine, and he didn't qualify for Maine lemon law, so we knew that was out. But we had a cash settlement that was slightly below what he wanted. It wasn't a huge difference, but it was under what he was looking for. And so he asked me, well, if we go to litigation, there's no way that a judge can find against me, right? I mean, look at this case. And I was like, well, that's not really the issue here, right? Let's say a judge up and down 100% agrees with you that you've been done wrong, that they completely messed this car up. He's then going to look to the law and say, okay, what am I allowed to award this person? They can't go rogue and just award whatever they want. They can't say, I'm going to give him a repurchase because I want to, because then that can be appealed too, like you said, and then that goes up to the higher courts to determine, because it could be an error of law. They have to follow what the law says and award what the law allows. So we had to review, loss in value and how that's assessed in terms of a percentage of your purchase price back. And I told him, even in the most severe of cases, we're usually looking at somewhere between like 20%, right? And that's in a really severe case. Usually, like you said, it's closer to 10 to 15. And we had over 20% as the offer. And so I was like, it just doesn't, I don't feel right? I don't feel right taking this to court when we're within what I would expect and where our expert would land, which again, we didn't have his report. We didn't know where he would come in. So it's not really worth the risk when we're so close together. Usually, as I explain to clients, when we're just like not even in the ballpark, right? We think the case is valued at $12,000 and they've got a $2,000 offer, right? Not even close. It's worth all the risks. Let's just go for it. Those are the times in which litigation can really be helpful and can help push it through. But it's, checks and balances. You got to kind of weigh the scales to see which option works better for you. Now, if a client does take a cash offer, Stephen, I'll let you talk about, because a lot of them ask about the tax implications. Now, we're not accountants. We know that. And we always recommend that you consult with one. But I'll let you talk about what our understanding is in relation to these settlements, whether it's repurchase money or a cash and keep refund. Where does that leave the consumer tax-wise?
When a consumer agrees to a cash and keep settlement, that is, like Emma said, a very big question that we get all the time. Well, do I have to pay taxes? Is this going to be taxed? It's always best to check with a tax consultant just to be sure. But however, you are essentially receiving your money back that you've already paid, and that was already taxed as well.
And in terms of timing of repurchases, replacement, and these checks, Courtney, I'll let you talk about it. I mean, it's sort of all over the board, right? It depends on who the manufacturer is, but repurchases and replacements especially, they really are a process. There is actual paperwork and things that need to be done that clients don't always understand. So I'll let you talk about what the timing looks like for a purchase. I'll let you talk about what the timing looks like for a repurchase or replacement versus a cash settlement.
Yeah, unfortunately, it's not an overnight process with the repurchases. There are so many channels and avenues that it all has to go through, so many numbers and documents that need to be gone over. So generally, it's going to be a 60 to 90-day period from the time the settlement is agreed to until you are actually surrendering that vehicle. For certain manufacturers, though, Kia being one of them, it can often take up to 5 months, which does seem like an astronomical amount of time. Just know that any payments that you make during that period of time are going to be refunded to you. You will get them back. It is just longer that you're going to kind of have to deal with the vehicle. Cash and keeps are generally quicker. Generally, we have the check within 45 to 60 days from the date that that settlement is agreed to when you sign that settlement release. So it is a whole lot faster.
That's usually the benefit of a cash and keep sometimes too, when the client just wants to trade the vehicle in. They know the money's coming. They know about when they're going to receive it. They just need to hold on to the car for maybe another 30 days. But as I also tell clients too, with a cash and keep settlement, once it's locked in, it's locked in. Once we've agreed upon it, you can go trade the vehicle in tomorrow. If you don't need this money to trade it in, by all means, go for it. Once we're confirmed, we're confirmed. As long as obviously we have the current registration and things we need, by all means, go ahead and get rid of it, and the money will come when it comes. Another important point to point out is that under either a repurchase, replacement, or a cash and keep settlement, the manufacturer is still responsible for attorney's fees and costs. That's another big question that we have, or clients wonder, is there a difference? Are you going to get a portion of my repurchase money? Or if I'm getting a replacement car, there's no money really being exchanged other than maybe if they have to pay for the extra MSRP, how do you get paid? So under the Lemon laws and breach of warranty laws in each state, the manufacturer is responsible for paying our fees in addition to the repurchase, replacement, or cash recovery. So in either scenario, fortunately, attorney's fees are covered, and it's not something that then also has to weigh on our clients in terms of which option do I take. That's just not a concern. The manufacturer takes care of that, and they can look more at their current situation and what works best for them in terms of their future and what vehicle they need to be able to get back to a normal functioning life. And with that, I think we've covered pretty much everything today and the three main options that you have when you have a lemon law case. Again, there's always more information on our website, lemonlawcar.com, or we also have our intake line, 8334-CAR-LAW, where we give free consultations to anybody that calls in that may have some questions on their vehicle or the lemon laws in their state. And with that, we thank you for listening, and we'll see you next week.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary as outcomes are determined on a case-by-case basis.